There were three such cases. The first of this case was Obata Ambak Holdings Sdn Bhd versus Prema Bonanza Sdn Bhd. In this case, Obata is the purchaser of a condominium known as Central Residence. Prema Bonanza is the developer. Like in Ang Ming Lee, Prema Bonanza applied to the controller under Regulation 11 Sub 3 for an extension of time for the delivery of the vacant possession. The controller granted the EOT on the 16th of December 2010. Extending the delivery of the vacant possession from 36 to 54 months. Now, what is peculiar in this case is that at the time of granting of the EOT on the 16th of December, Prema had not executed the SPAs with the purchasers. Obata only had entered into the SPAs on the 11th and 18th of July 2012. Thus, when Obata entered into the SPA, it had already contained the amended extension of time. In this case, clauses 25 and 27 of the SPA in Schedule H of the HDA provided that the vendor shall deliver the parcel and the common facility respectively within 54 months rather than 36 months from the date of the SPA. After the decision of Ang Ming Lee, Obata commenced an action against Prema Bonanza for LAD, arguing that both clauses 25 and 27 were invalid and that the EOT granted by the controller was void following Ang Ming Lee. Now, at the High Court, Obata's claim was struck out because at the time when the development was launched or when the controller had granted the EOT, Ang Ming Lee was not decided yet. It was also struck out because Obata was time-barred from filing their claim. Under the Limitation Act of 1953, Obata must commence their suit within 6 years from the date of the cause of action. Since Obata's claim is premised on the amendment to clauses 25 and 27 of the SPA, it was held that the time starts to run from the date of execution of the SPAs, which means Obata had to commence his action before the 10th and 17th of July 2018. Obata only commenced the suit on June 2020. Thus was held to be time-barred. Obata appealed to the Court of Appeal, but the High Court's decision was upheld. Then there is a second case of Prema Bonanza Sdn Bhd versus Vignesh Naidu Anak Lelaki Kupusami Naidu, which involved the same projects as Obata's. The facts are somewhat similar to Obata's, only that in this case, Vignesh's SPA was entered on the 18th of July 2012 for his unit. Like in Obata, Vignesh's claim for LAD was struck out at the High Court. However, unlike Obata, the Court of Appeal reversed the High Court's decision and allowed Vignesh's LAD. Unlike Obata, however, number one, the Court of Appeal held that Ang Ming Lee would apply retrospectively, meaning the controller's decision in granting the EOT in 16 December 2010 was void and of no effect. Number two, Vignesh's right to claim for LAD only arose on the date he accepted delivery of vacant possession of his unit. Since he was deemed to have taken vacant possession of his unit in early February 2017, he was still within the limitation period.